Hi, I'm Debbie Moraes. Once again, this is Legal Matters, the program that's been designed to address the current, critical, and sometimes contentious issues that are facing businesses and consumers today. It's legal information, it's practical solutions, and straight talk about a wide variety of topics that will affect your home and work life. We want to begin by welcoming and thanking from the Bazar, Grasso law firm in East Providence, David Bazar. We wish Jackie were with us next time. We are going to address today the issue of constitutional rights and civil rights, which seem to be in conflict these days. New controversial questions are being raised as a result of how some of our basic civil rights are being exercised or becoming manifest. Protests, tweets, graffiti, drones, all of them are in the news. The First Amendment, we've talked about before, we're going to address that. Even the Sixth Amendment, which addresses how you will be able to confront an accuser or confront someone, it gets lost in cyberspace these days. So to start, the right to exercise your freedom of speech and the right to assemble peaceably has been in the news locally here. It might even recall the hit movie of Selma, where there's some practical issue about protests. But right now we have Rhode Island lawmakers and Massachusetts lawmakers who are proposing laws to make it tougher or get tougher on the protesters who are blocking the highways. So we'll be covering that. We'll talk a little bit about the free speech that now has turned to encompass threats of rape and death and even exposing pictures that shouldn't be for someone you like or didn't like or once liked. And also, how is that playing out? Now we have these things that are going to felony courts and there are fines, sometimes just merely being addressed by op-ed pieces. So what's the law? Let's sort this out. What's evolving? David, let's get to it. I think the first thing ends up being an issue about First Amendment, which we have addressed. Do you want to quickly give us a recap and then we'll take off from there?
Well, I think the portion of the First Amendment that you're really dealing with is the right to assemble and also the right to free speech. So there are certain guarantees in the Constitution that are protected both on the federal and the state level through the Fifth Amendment, the 14th Amendment, and due process and all of those types of things. So long and short of it is, as the legislature tries to address some of these issues, they have to weigh and balance people's constitutional rights against safety and other issues that they're looking at.
So right after the Ferguson story happened, when people were unhappy about the outcome of that particular case, suddenly we have, from Rhode Island to Massachusetts, people who decide that they are going to demonstrate, peaceably assemble. They have something to say, and you say they have a right to say it. That's First Amendment rights.
Correct.
So what happens when there are some concerns about these gatherings that are now possibly threatening public safety, which is, I guess, what prompted these legislators to take some action?
So the issue locally was the groups that were assembling and marching eventually, as I understand it, reached the highway, the Freeway 95, and were blocking traffic. And so their right to assemble and protest and have their voices heard was being in conflict with the rights of people to drive their cars down the road and travel, which is also a constitutionally protected right. So freedom of movement versus freedom of expression, I guess you could say, is what you were looking at, and also safety issues, because it's not safe to block a highway, especially an interstate highway. So as you try to weigh and balance those rights, there are certain things that you can do to restrict people's rights to some degree, and when that legislation's passed, courts then have to weigh and balance. Is it the least restrictive way to restrict those rights, or is there a way of doing it in a less restrictive fashion, so to speak?
So with that said, if someone is thinking back to the 60s when the story of Selma happened, with a Bloody Sunday, when they were walking in the streets, they absolutely were in the streets and they were probably blocking passageway. But of course, the ruling was that that was an okay way. It was absolutely acceptable. And their point was obviously about racial issues. So here it is, fast forward several decades later, and the same kind of thing is happening where these people are assembled peaceably, they have something to say, they think it's important, this is their way to do it. Now, they're either going to be fined more heavily or put in jail for a longer period of time. Does this require a new set of laws, such as those that are being promulgated in Rhode Island and also in Mass?
Well, going back to the protests in the 60s over civil rights violations, I believe some of them was the right to vote, and it was a protest of the injustices that were being done in stopping people from registering to vote and that type of thing. So they were marching from Selma to the Capitol, and it was not an interstate highway that they were blocking. Sure, there was a bridge, but they were moving along, and they would have been moving along but for the atrocities that were being done by the other folks around them, including the law enforcement at the time. So it's a similar situation, but what the legislation would do in the instant case is not stop people from being able to protest, but maybe where you can protest. And it's not uncommon. There's precedent for this. Anti-abortion activists often want to protest in front of clinics. And I know there's some rules that are in place as to how close they can be to the clinic, what they can do, and how they can do it. They're not saying in the legislation that you don't have the right to protest. They're just limiting where you can protest.
So apparently there's been much back and forth in the press, never mind the legislators who are trying to say we need to have stiffer fines, stiffer penalties, and incarceration. But apparently the courts are actually weighing in on this too already and saying that they do have the right to protest. And I guess they bring up as the counterpoint to that, how could you say that someone should be fined or go to jail for this when in fact people who are going to sports events sometimes cause traffic and blocks the same ambulance that was trying to get someone to the hospital across 95 when there were protesters. Now you have the ambulance that can't make its way through when you have people just trying to go to a soccer game, football game, or whatever. We're going to have a new set of laws for these, should we?
It's a fine line, and you have to tread very carefully when you're doing anything that limits somebody's constitutional rights in any manner. And as I understand it, and I have not read the legislation that's being proposed or know exactly what they're trying to do, but if it's done in such a way that says you can do this, and you don't have to do it here, but you can do it there, and it doesn't affect the message that's being delivered, because part of the issue is, there are messages that you may agree with or disagree with, but we should all agree that everyone has the right to deliver their message. But sometimes where the message is delivered and how the message is delivered can be an issue. We always talk about the right to free speech, but we all cite the famous case or saying that you can say what you want, but you can't yell fire in a crowded movie theater because of the dangers associated with that. So there's all of these types of things that you have to weigh and balance. And in the end, the bottom line is, can something be crafted that keeps the protesters safe, other people's safety in view, and doesn't limit to any large degree the right to protest or how you protest?
So it certainly makes sense that if they were walking across the street, across the 95, and an ambulance needs to go by, they have sirens. If the crowd just parts, why should there be more of a fine? Do you think that we need to go so far as to say this is felony worthy?
Well, I think it certainly should be felony worthy if they don't part and let the emergency vehicle through. My concern is less that they would do that, although that's possible, and that certainly is something that should be, you've trumped the constitutional right to assemble in that spot when you've got somebody's life at stake and needs to get through. So if the legislation is, if you protest in such a way that it blocks somebody's emergency vehicle from going through, that's a felony. I don't have a problem with that. To say that you can't protest or do it in certain areas without having a compelling, this is the real key, there has to be a compelling reason to limit it, and you have to do it in the least restrictive way. So if you do both of those things, you both have the compelling reason and you do it in a very limited or less restrictive way, the least restrictive way that you can, then I'm okay with that kind of legislation. But you really have to think it through carefully. So if the legislation says you can protest, but it's a felony for not letting an emergency vehicle through while you're doing it, I don't have a problem with that. If it's, you can't protest here and there's no compelling reason for the here that they're picking, I don't really think that flies. I don't think it passes constitutional muster.
Hopefully, people who are weighing in on that will use that kind of rational thought in making some decisions.
It's actually the kind of analysis that a court is supposed to give that situation. So that's, I didn't make this up. This is what they're supposed to follow.
Well, even when they're talking about intentions, someone who's blocking traffic because they're going to a football game, they're not intentionally trying to block traffic. It was a consequence of their assembly, what was happening there. But by the time you start debating, well, so-and-so had no right to be a political activist. Now you're questioning their intentions. You're just saying it's about what the possible consequence could be and measure it that way.
Correct.
Makes perfect sense.
Right.
Sounds good. So apart from that kind of battering of my potential constitutional or civil rights, more commonly, more people are affected daily about email. There's a right of speech. I can say what I want. What happens by the time that is going to such verbal abuse as to threaten me, to threaten rape, murder, assault, or what happens then, David?
Well, we do have some laws already in place about cyber stalking and bullying and that type of thing. And free speech does not allow you to say anything you want, anytime you want. So if you are acting in such a way that's threatening somebody or cyber stalking somebody, the constant emails or text messages or whatever it might be, there is a remedy for that depending on the relationship between the people. It could be in family court, it could be in superior court, or it could cross the line and become a criminal type of case.
Is there any difference between someone who's walking down the street and threatening to do you harm, or whether or not it goes through the cyber fiber interspace
Right.
that seems to give you some degree of space? Does the
Yeah.
law look at that differently?
Not anymore. I believe that if, people used to think they could hide behind their computer screen and it was all protected and it didn't matter what you said or who you said it to because it was insulated. It's not. And the law does look at the same type of situation. Is if you're doing something and the effect of it has a consequence on somebody that is unwanted and unwarranted and crosses the line, then it's just as enforceable as if you did it in person.
Does there need to be some sort of, never mind a law, but a consistency between what happens, say, here and across the pond? For example, an email that threatens someone in the United States versus someone that has received a message in England. In the story that I just recently read, someone received a message in England, and suddenly, when they were able to trace who that person was, that person found himself behind bars for several months with a serious amount of fines to pay. We haven't been hearing that that's been happening lately in the U.S. Should it be, and should there be some sort of consequence that is consistent that everybody can know right up front, if you do this, there will be this consequence, known and finite and understood?
So let me understand the situation that you're presenting. Someone from England was cyber stalking or harassing or doing something to someone in the United States?
No, in England. It happened in England. But the same thing does not seem to happen in the U.S. Someone in England was cyber stalked, was threatened, and that when they traced it, they found out who it was, and they were incarcerated for a few months with a heavy fine. But it hasn't happened similarly in the U.S.
You're saying that it happened in England?
In England.
Both sides
Both
were in
sides,
England.
yes.
So I'm telling you, in the United States, if that happens, there are consequences, and the same thing can happen.
It can.
And there was a case, I'm trying to remember, not that long ago, where somebody who owned a store locally, I can't remember exactly what it was threatening, they at least alleged that she was threatening somebody and traced it to a library where they said she was doing it from and charged her. And I think there may have been something where they found it wasn't actually her, it wasn't what they thought it was, and maybe didn't press the charges. But if she had been, certainly she would have faced fines and possible prison and all of those things.
Okay, and let's address the victims' rights for a moment. It makes sense if it came by email. I'd be the first one to contact the Verizon, the Comcast, or whoever the carrier is and let them know. However, when I explored that, they will tell you that this, please do not reply to this message. Unfortunately, we can't investigate or respond to each email that we receive, but we'll attempt to identify, they might not, and review those emails which we think action is needed. What else can you do? I mean, you might be able to say, gee, I'd like to find out who else is sending messages from an unknown email address that's made up somehow. What can we do if you're the victim of this?
So are you saying if you don't know who it is?
You don't know who it is, but it came through some peculiar email and you
Right.
clicked on it. Perhaps not, should not have.
Should not. We've done those shows.
Yes.
And yes, don't click on something you don't know where it came from for a whole host of other reasons.
Yes.
But so you click on it and it's this threatening email, but you don't know where it came from. So ignore it and you get another one.
And another, so that you feel threatened and you have been harassed.
Right.
And what happens?
State police. I
State
would call
police.
the state police, and they have a computer area of folks who are experts in this area, and if they think that the threat's warranted and that there's some danger to you, they'll investigate it.
And it sounds interesting. It sounds that that's correct. It was fairly interesting to see that the phone carrier had said, the email carrier said that they couldn't trace these or wouldn't, but to stay vigilant. Meanwhile, if it had been child porn that had been sent by way of email, then there's another separate line and a separate missing and exploited children crimes division or something that would try to pursue it a little bit more heavily. But it seems to me that an adult has some rights to feel protected too and feel that they're going to
Right.
be checked out and somehow have some sort of recourse for some perpetrator.
And that's why they have these areas of expertise in different police departments, and I know the state police have it. If it's a federal issue, you might be able to do it through the FBI, for example. But the FBI, I don't think, is going to investigate an anonymous email that's been sent to you once with some anonymous threats that don't really amount to much. But if it is something real and something that they think is actionable, they'll at least get you to the appropriate authorities to follow up on it.
Okay, and moving on to a different kind of speech, but New York Times recently in the review section talked about the epidemic of facelessness, referring to Twitter. A world without faces is stripped not only of ethics, but of biological and cultural foundation. Before we get specific, can a lack of ethics and cultural foundation or whatever, can that ever be legislated? Can that enter into a topic about proposed new laws?
It's really hard to legislate ethics and common sense and decency and all of those kinds of things. But when things become so bad and so out of bounds, then they cross the criminal laws, and that's really the best protection that you have. You can't, and you don't want to, I don't think, try to legislate how people have to act in a reasonable manner every day. But we do hold people accountable to how they act if their actions amount to what society has deemed criminal, or if their actions have injured somebody or crossed the line in that way, so that they're held accountable for their actions on a civil level. But we have criminal and civil law to really legislate that, and sometimes the less law the better, depending on the situation.
That sounds reasonable. Of course, if someone is saying that they've received the tweets and retweets that have been faceless, it's faceless rage. So some people may absolutely ignore it. Others take it to heart, and we hear that there's PTSD cases that arise from it, and some are calling police saying, I really do feel threatened. I feel that someone might actually act on this threat or whatever that's coming anonymously. I don't even know where not to look or where to look. What do you do with these things?
So post-traumatic stress disorder, from receiving emails or something like that, not knowing who they're from or what they're about, or there's no context to them.
And they're incessant, and someone puts a panic button in their room. This actually happened because they were so frightened.
How about this? And I don't know the context of that, but if I was getting emails that I thought were more in the nature of spam, that I didn't know how they were being directed to me or whatever, I'd consider changing my email address and seeing what happened then. And if they did continue, then perhaps a call to the police if the same thing is following, and maybe then they can trace it back. Because remember, they have the ability to get more information and will get more cooperation from the computer companies than you will.
But of course, Twitter has said they feel badly, but they don't really feel like they want to disclose all that much. They haven't really been very willing to be that forthcoming. But in these circumstances where someone's getting a trail or an incessant line of tweets and retweets that make them feel threatened, so that they are threatened for their physical safety and put in a panic button, certainly you've reached something that's a different kind of level. I don't know if there's something wrong with the person receiving that too. You could argue that. But nevertheless, you have a right to not be harassed.
Right. So I would suggest that if it got to that level, and it's not something criminal that the police can help you with, and it's not something that, and I'm not that familiar with Twitter or tweeting or all of that, to be honest, but if it's something that can't be changed or fixed with the change of what I would call an address or username or whatever they might call it, and Twitter could help you but refuses to, then maybe you do have a claim civilly against Twitter.
Okay. And what happens when the police come to the doors of men or women who are sending out tweets and notes to strangers saying they want to rape them or whatever, and say it's a young person, either they or the parents are absolutely shocked that sometimes they do trace them and they have police come knocking at their door, and they said, the police will say, we do have to take these online comments seriously. If you're the representative of the council for the one who's doing these tweets, emails, or whatever, what do you say?
Well, it would be just like any other threat. You know, back in the day before we had these computers and tweets and Twitters and emails and all of those things, there was mail and threats made through the mail and all of those things, and you would have to investigate it just like you would any other case back then. Today is, what is the motivation? What's behind this? What is it really your account? Did someone hack your account? Where is this all coming from? You need to understand and get all the information you can to determine whether or not there really is a case against your client.
Okay, so you'd be checking out the factual basis of all of this. Is there a defense about it there being an arm's length distance so it's a little less real? Is that part of a viable defense these days?
Well, not really.
No.
It is if, you know, we'll go back to these cases in law school and type of thing where can you be charged with attempted murder if you're using a water pistol, a squirt gun to threaten someone. And so there has to be some connection between, in this case, the email or tweets that are being sent out and an ability or a likelihood to follow up on them and really do something about them. So if there's really a remoteness to them from any reality of what's going to be done, then there's a defense. But just because it's done through Twitter or through email or whatever, in and of itself is not a defense.
Okay, we can't just toss it aside. I mean, it makes perfect sense that if it was a snide remark, you would just tell someone, ignore it. But if it's feeling like it's a rape threat, you might not feel so inclined to be dismissive of it.
Right, and again, you then have to go put all of this into context and have all of the facts surrounding it and try to determine whether or not there's any basis for what's being done or if it's just sort of like the difference between fraud in a transaction and salesman puffing. You know, the car I'm trying to sell you, this is the best 1969 Cadillac ever built. Okay, well that's just a salesman making statements. But if the salesman said, this is a 1969 Cadillac, belonged to Elvis Presley and has a very rare engine in it, and none of those things turn out to be true, then it crosses the line. So is it puffing or is it fraud? Is it a threat or is it just someone saying things that really is meaningless?
And what about the issue that when we're talking about cyberspace, that Sixth Amendment that says we should be able to confront someone, you take someone to court, you can confront the accuser. In the world of cyberspace, does that change? How does that change considering you really can't confront that witness yourself? You may not even see him ever.
The confront and cross-examine your witness is about a trial. So if the person is threatening you and now there's a lawsuit and they're a part of the lawsuit, you're not going to do it through the computer. They're going to be brought into court.
That's how you make it less faceless.
Right, exactly.
Do you think that that should be happening, that people should be pursuing these when there really are what seem to be bona fide threats, that they should pursue this and take it very seriously?
If there's a real threat, there's a real possibility of something happening that's dangerous or shouldn't happen, or you're feeling threatened legitimately, reasonably, then yes, that should be followed up on. If it's just, you know what, I'm annoyed by these things and I don't want to be bothered by them and it's faceless and we don't even know where they're coming from and it's anonymous and it's sort of meaningless, then ignore it. But you have to act reasonably. And everybody involved in these things needs to think about it from what would a reasonable person do. And if a reasonable person would act in a serious manner to what's being sent or threatened to them or whatever, then it should be taken seriously.
Okay, and now, in not talking about threats of rape, how about just an example of a senior director of corporate communication tweets little indignities while she's flying on a long journey home to South Africa. So in these tweets go something like, I'm heading home to Africa, hope I don't get AIDS, just kidding, I'm white. Another one, weird German dude in first class, get some deodorant. So it's an 11-hour flight. These two tweets go viral. Long story short, the internet explodes, and while she's sleeping, probably peaceably. So it's considered a disgusting, racist tweet. And comments are flying, how did she get her job? Her employer says, we'll take care of it, we can't reach her. But meanwhile, hashtags erupt that says there's worldwide, we should be on the lookout for her. By the time she lands, long story short, someone takes pictures of her, it too goes viral. She is fired. Is that a reasonable consequence? Is that a legal thing? Is she really causing any, is she betraying any First Amendment, or is that being violated? What about how other people on the receiving end are feeling about that? What do you think, apart from the fact that it's rude?
So remember, the Constitution protects you from the government. So if your employer thinks you said something or did something that violates their standard of decency or their rules, and they're correct, they can fire you. But if you say something that should be protected and they fire you for it, and it's not connected to their business at all and doesn't affect their business, then you would have a claim against them. So exactly what she did and what her position was and what her job was and why she was on that plane and all of those things would affect whether the company acted reasonably or not. So not knowing all those, I can't comment on it other than to say it depends.
Okay. Quickly then, graffiti. We've talked about it before. Suppose now the graffiti gets escalated to insults about Allah and it's considered to be a hate crime. Does that change the nature of it? We have a little bit of time left.
Okay, so on the little bit of time we have left, I'll say this, that first of all, if someone takes to graffiti to someone's private property, it's still destruction of property or defacing property, it's a crime. When you do it in such a manner that you're offending people or doing it such as that as a racist kind of thing, then it can be a hate crime and it does jump it up a whole nother level.
In terms of it not being legal or just in what the consequence will be?
It's a criminal case legally. Hate crimes are legislated as hate crimes and it's a separate legal matter and it's not protected by free speech. You don't have the right to do that.
Good to know. There were so many more things, scenarios that we could talk about. Perhaps we will soon. We want to say thank you for tuning in to Legal Matters. Our discussion of legal matters will continue. Please stay tuned and join us.